Can a special needs trust be modified or decanted in New Jersey? Creating a special needs trust, S&T, ensures that a child or loved one with disabilities receives supplemental support without losing means-tested benefits. In an S&T, a trustee manages settlement proceeds or family contributions and distributes money for out-of-pocket medical care, adaptive technology, transportation or educational opportunities. These assets are not treated as the beneficiary's property, so Medicaid and Supplemental Security Income remain available. Because public benefits depend on that separation, the trust must be irrevocable. After establishing it, the settlor cannot undo it or reclaim the funds. The law firm stresses that while the trust is irrevocable, guidance from a lawyer can help you adjust it when circumstances change. The irrevocable structure works with New Jersey's sole benefit rule, which requires that trust funds be used only to enhance the beneficiary's quality of life. Shared housing expenses, gifts to relatives or payments that primarily serve others are generally not allowed. Any change to a trust must preserve both irrevocability and the sole benefit purpose. Even a well-planned trust can become outdated. A child's health might improve, prompting them to pursue education or work. Conversely, declining health could require more intensive care. Tax or Medicaid rules change, trustees may retire or pass away, families relocate to states with different benefit laws, or administrative costs outweigh the trust's benefits. In these circumstances, families wonder whether they can modify the trust to fit current needs. Under the New Jersey Uniform Trust Code, there are three primary methods. First, modification by consent allows the trustee and all beneficiaries to alter or even terminate a non-charitable irrevocable trust when no material purpose is violated. Preserving eligibility for Medicaid or Supplemental Security Income is a material purpose. If one beneficiary objects, a court may still approve the change if it finds that unanimous consent would be valid and the objector's interests remain protected. Second, NJSA Section 3B, 31-28 authorizes courts to modify trusts when unforeseen events make the original terms impractical. For example, in a 2024 case, a New Jersey court allowed termination of an S&T after the family moved to Brazil because the trust's original goal, maintaining New Jersey Medicaid, was no longer relevant. Third, non-judicial settlement agreements let parties resolve administrative issues, such as clarifying ambiguous language or appointing a new trustee, without changing what the trust can distribute. Before making any changes, trustees should consult a knowledgeable lawyer to ensure the modification aligns with the trust's purpose and statutory requirements. Decanting is another option. Much like decanting wine, a trustee may pour assets from the existing irrevocable trust into a new trust that contains updated provisions. New Jersey has no specific statute, so courts apply common law principles. If a trustee has absolute discretion to distribute funds for the beneficiary's best interests, that authority typically includes the power to decant. If their discretion is limited to specific standards, often health, education, maintenance and support, decanting is unavailable. Decanting can correct drafting errors, add special needs protections to an older trust, update administrative terms or improve asset protection when a beneficiary faces legal or personal challenges. Because it does not require beneficiary consent, decanting can be used when families cannot unanimously agree or need to act quickly. Trustees should consult a qualified attorney to assess the trust language and ensure decanting complies with New Jersey law. Although special needs trusts are irrevocable, the law recognizes that families' circumstances evolve. New Jersey provides pathways to modify or decant an S&T without jeopardizing public benefits, but each method has specific requirements. A skilled lawyer or attorney can explain whether modification by consent, a court petition, a settlement agreement or decanting fits your situation. The Matus Law Group, a dedicated law firm at 81 East Water Street No. 2C, Toms River, New Jersey, 08753, guides families through special needs planning. Their attorney Christine Matus and her team bring personal experience to each case. To discuss whether your trust still meets its purpose, call 732-281-0060.